does a parenting coordinator have decision-making authority, or do they just make recommendations?
So
This is Family Law Insider, and I'm Katie VanDeusen, the managing partner of Sterling Lawyers. And I have with me today Senior Associate Cynthia Toscano, and we're going to be talking about parenting coordinators and therapy in Illinois family law. These types of professionals can typically be involved in either parentage cases or divorce cases. So we want to talk through the differences and give the listeners an idea of what the key differences between these two are and what to expect with each one. So Cynthia, let's first start with parenting coordinators. So what exactly is a parenting coordinator?
So, a parenting coordinator is actually a fairly new role that's been established in Illinois. The statute was just passed a couple years ago. I want to say 2 years ago, but I could be wrong. But parenting coordinators really are legal professionals. They are private attorneys that have gone through specialized training to be deemed parenting coordinators that have experience in family law. Usually they have a background in being guardian ad litem for the court, and they really are, trained legally to sort of interpret the statute and sort of help guide parties through disagreements that they may have in their co-parenting journey.
Okay. And then in terms of a parenting coordinator's involvement, do they typically assist with more minor issues or major issues? Both? Kind of how does that work?
So because it is a fairly new statute, I feel like we're still in a little bit of a gray area where we're sort of, exploring the waters and making those determinations. But from what I've seen since the statute was passed, it really seems like judges are not comfortable with sort of leaving what we call quote unquote major issues up to parenting coordinators. They sort of see that as them delegating their judicial power to, a non-judge. So they tend to only appoint parenting coordinators to help in sort of high conflict cases where the parties are always having disagreements over what we call minor issues. Things like, can I have vacation parenting time this week in the summer, or does it have to be this week? Or our parenting plan prohibits 3 weekends in a row. If I take vacation now, are we going to be in violation of our parenting plan? Sort of little minor issues like that of not only interpreting the statute, but a lot of times interpreting court orders or parenting plans. Nothing really major like, can I switch my child's school? Or, can I put my child on a specific medical treatment? Like those sort of major life-changing decisions and issues really are still within the purview of the court.
And then in your experience, have you seen that certain counties are more apt to appoint parenting coordinators or not?
To be honest with you, it seems like judges are still somewhat hesitant to appoint parenting coordinators, again, because I feel like we're still in this sort of stage where we're trying to gauge and figure out like what role they really play in our system.
Mhm.
But I do have to say, I have noticed a bit of a pattern with sort of what we call the collar counties, meaning surrounding Cook County, like DuPage, Kane, Will, McHenry, the Chicagoland counties, being a little bit more hesitant to appoint parenting coordinators as opposed to Cook County. In my own personal opinion, this is nothing factual or statistic in nature, just my personal opinion based on my experience, is that those collar counties, those judges tend to have a smaller caseload. So they are okay with maybe some cases lingering on their call or them having to step in to address certain issues if the need be, as opposed to in Cook County, where judges have much more voluminous calls. And while they would love to be able to work through and talk through every single minor issues that the parties have, they really just don't have the capacity in terms of time and resources. So they are a little bit more willing to sort of delegate some of these what we consider more minor issues to parenting coordinators to sort of relieve the pressure that they might have because of their more voluminous calls.
I couldn't agree more. So, in my experience, Cook County has adopted that statute for parenting coordinators. So, the court has the authority to appoint a parenting coordinator. Whereas I think in some of those collar counties, they have not yet fully adopted the statute. And it's more of a circumstance where if both parties agree to appoint a parenting coordinator, they can enter that agreed order and the court will honor that agreement. However, if there's a dispute or a disagreement as to appointment, the courts in those collar counties, specifically DuPage, Kane, Kendall, I think they are not in a position where the judge would order it. So it's very unique and interesting to see the different interplay with how each county kind of handles things differently. So going back to parenting coordinators, I think you kind of touched on this, Cynthia, but I want to dig into it a little bit more. Does a parenting coordinator have decision-making authority, or do they just make recommendations?
So there is no uniform way of addressing this because the statute is not clear in that regard. And there is no form order that every county uses across the state that sort of specifies exactly what a parenting coordinator can or cannot do. There, are a couple of things that are fairly common in parenting coordinator orders, but nothing that's, uniform in nature. So I would say 9 times out of 10, because judges are hesitant to, like I said, delegate their judicial power or their decision making power to a non judge, they'll be very clear in the parenting coordinator order that these are recommendations only and they are not binding on the parties. But I have had a couple very specific circumstances where the parties have just been so litigious and the judge is just like at their wits' end in regards to these constant minor issues that keep coming up, that they do sort of tweak that and sometimes say that while parenting coordinator recommendations cannot legally be binding on the parties at all times, they do sort of put a little caveats in there that if you decide to disregard a recommendation by a parenting coordinator and still return to court, there might be some potential ramifications to that, like payment of attorney's fees or things of that nature, to sort of disincentivize the parties from sort of saying, oh, well, they're just the parenting coordinator. It's just a recommendation. I can ignore that and continue to litigate the issues. So
That's exactly. It kind of begs that question of, if these are just recommendations and there's no authority really with that parenting coordinator, like what's the point, right? Like if someone can just say, well, I didn't really like what the parenting coordinator said, so I'm just going to ignore that. It almost begs the question of like whether or not that parenting coordinator would really be beneficial in a certain circumstance. But I absolutely see the flip side to that from a judge's standpoint of a judge is a judge for a reason and they sit in that seat and they are the ultimate decision maker. And so they don't really want a parenting coordinator to somehow like usurp that role or that responsibility too. Have you ever had any experience where you feel like maybe you had a very litigious case and a parenting coordinator would have been really helpful? And can you give examples of how you think a parenting coordinator might be able to assist certain parties?
absolutely. I actually have had to file motions for parenting coordinators in specific cases. There was a couple times it was done by agreement. There was a couple times that it was being fought. And I think one important factor that we also have to consider when discussing this in specific cases with our clients is the cost factor, because parenting
Okay.
coordinators like guardian ad litems are not a free service provided by the court. There is a cost associated with them. And that sort of is also part of what we quote unquote call having skin in the game. Like if you are going to continue to be making, what we call mountains out of molehills, well, then there should be some sort of cost associated with that to sort of disincentivize that sort of behavior. But I do think that the cases where parenting coordinators are the most helpful are in cases where the parties have communication issues, and that leads to highly litigious cases, not the cases where the parties, to be honest with you, are litigious just because they hate each other. Because if I'm being honest with you, if it's really that emotional factor coming into play and it's like, I want to litigate this, not because you and I can't communicate, but because we have these lingering feelings and we just dislike each other and we're unable to sort of place the best interest of our children above that, then these people are going to find a way to litigate no matter what, no matter who you appoint or what recommendation you give them. Like, unfortunately, those very small subset of cases, it's really hard to, fix that issue even with the parenting coordinator. But in certain situations where it's not that the parties sort of, have these lingering dislikes for each other, it's really just that they can't properly communicate. They have different communication styles. They have different ways of interpreting the order. They have certain people in their ears saying, well, this happened in my case, so I don't understand why this is happening in yours. Things like that. Then a parenting coordinator can be very helpful in saying like, no, I am a legal professional. I am familiar with the statute. I'm familiar with the facts in your case. I've read over the parenting plan. And if we were to take this to court, I believe that this is what a judge would do. So based on that, this is what my recommendation is. And when parties have the ability to sort of process that logically, putting the emotion aside, in those specific cases, parenting coordinators can actually be very helpful, because even though there is a cost associated to parenting coordinators, it is still going to be much more cost effective to deal with those issues with the parenting coordinator as opposed to with an attorney before court.
Yeah, or any type of, extensive litigation before a judge or depositions or trial. It just, those costs add up when you're dealing with an attorney at a certain billable rate versus, maybe using these other professionals or tools that you can to maybe mitigate that cost or that exposure.
Absolutely.
Let me ask you this, Cynthia. So, kind of switching gears again and comparing therapy and when, a court can recommend therapy. I know you kind of alluded to, hey, sometimes you just have parties who literally will never get along. They truly do just hate each other, dislike each other to a point where it bleeds into constant litigation. In your experience, when would a court order or recommend therapy for a party or a child to go to therapy?
Absolutely. I think there are fairly common scenarios where therapy really is something that is at the court's forefront. The first scenario that really comes to mind is what we refer to as reunification therapy. So, if there has been any scenario where there's been some sort of estrangement between a child and a parent, regardless of the reason for the estrangement, whether it's alienation, whether it's something that the parent themselves did, the reason is not important. Just the fact that there is an estrangement and there is sort of, I would say, reunification and healing process that needs to occur in the relationship between the parent and that child. Reunification therapy is actually something that courts order, I would say, fairly often in those situations. When it comes to individual therapy, I think a lot of times this comes up in the context of allegations of endangerment. So if there's been any sort of situation in a case where one party is alleging that the other party has engaged in any sort of behaviors that could endanger the child, and that doesn't just mean like physical safety endangerment, it could also mean emotional, psychological endangerment, alienating behaviors. In that situation, it's very likely for the court to order therapy for the child to sort of address those underlying issues and also to determine whether or not this endangerment is actually occurring. Because a lot of times, especially when it comes to like emotional and mental endangerment, it's very hard to have corroborating evidence for that. And a lot of times, therapy is a really good way to determine whether or not that's actually occurring. And not only just determine it, but also assist the child in working through these issues. When it comes to therapy for the parties, they are adults. And to a certain extent, adults do have the ability to make decisions for their own lives and their own children, so long as, again, it doesn't lead to endangerment. So when it comes to therapy for the parties, the only real scenarios where courts really, I would say, consider or order therapy for the parties is, again, if it's in this context of like reunification, if there has been some proven endangerment of the child and the judge does believe that therapy would assist in making sure that those behaviors or that incident does not occur again. Or the third situation really is as a result of these 215 evaluations, or if there is some sort of confirmed diagnosis, even without a 215 evaluation, any sort of, diagnosed, proven mental health problems of one of the parties. In that scenario, it'd be likely that a court would want a parent to be continually participating in therapy to make sure that those underlying mental health issues aren't addressed and don't cause any ongoing concerns for the child.
And do you feel like what has been your experience, let's say, where one parent wants the child to go to therapy and another parent really maybe might strongly object? What is your experience with like requesting that type of relief from a court? Are they apt to say, yes, this child should be in therapy and order that? And, that may be against one of the parents' wishes. What's your experience with that, Cynthia?
My experience with that is very similar to my experience with the request for 215 evaluations, where if one parent has a reasonable basis for requesting it, like there is a reasonable belief that the children might benefit for therapy, and the other party is objecting for reasons that are not financial in nature, a court really does raise its eyebrow as to why would you not want your children to participate in therapy? Like this is not something that really causes them any undue harm. And even with
Right.
financial objections, we've gotten to the point where there are a lot of places that offer sliding scale or that take insurance or things of that nature. So sometimes even financial objections are sort of looked at, sort of sideways, because therapy really is something that ultimately most people benefit from. And if there are allegations of endangerment against that parent, it sort of gives the underlying thought of, well, these allegations of endangerment are being made against you and you don't want your child to participate in therapy. is there an ulterior motive for that? Like, is it that you want to prevent corroborating evidence from coming to light to the court? So it's one of those things where it's like, if you got nothing to hide, then really what is the basis for objecting, especially when there are so many cost effective methods of addressing this for the children?
What good points in terms of like how a court could view that skeptically. Like, why would you object to that? And especially exactly like you described, the cost and the different options that are now available, it almost would call into question like what is your motivation, right? And then in terms of therapy records or opinions, how do you, or what's been your experience with trying to utilize these in court as protected documents? Would a guardian ad litem be able to review those? What is your experience on getting that information in front of, let's say, a judge, and how you would go about doing that strategically as an attorney?
That is a great question because it can be a very complex issue. I think more complex than people realize because there are so many factors in play, especially when the children are a little bit older, because there is Illinois Mental Health Act in place that requires that any child over the age of 12 consents to the release of their mental health records, even if it is to a parent. So when the records are for a child younger than 12, usually a guardian ad litem is able to access it so long as the parties sign a release. And again, if you're refusing to sign a release, it sort of raises red flags to the court as to what you're trying to hide. So 9 times out of 10, the parties will sign the release so that the guardian ad litem is able to review these records. When the child is 12, again, that additional like factor comes into play where the child also has to sign a release. And depending on the relationship that the child might have with one or both parents, they might be hesitant to do that. And if they are hesitant to do that, courts aren't usually very, I would say, motivated to push children to do things against their will when there's, basis for why children have these sort of feelings against their parents. So typically they are fairly reviewed by guardian ad litem. A lot of times children, even over the age of 12, will sign the release because they want the guardian ad litem in the court to know what's been going on. They want to corroborate sort of their feelings and their thoughts and what they call their side of the story. But in terms of getting those records into proceedings as evidence, that becomes a little bit more difficult. And the guardian ad litem sort of is a vehicle to circumvent that, because if you have a guardian ad litem that has reviewed these records and can testify to them, you don't need to admit them into evidence. You don't have to worry about the Illinois Mental Health Act. You don't have to worry about HIPAA. You can just have the guardian ad litem sort of testify to this. So that's really the vehicle that most people use to sort of circumvent that issue and not have to worry about filing motions, having to put in protective orders, having to address not only state statutes, but federal statutes of privacy, because then it just gets too convoluted and too complex. So the guardian ad litem really is the most efficient and best vehicle to sort of get this evidence and these records sort of in a backdoor way so that the judge can consider them.
I could not agree more. And I also think it's difficult because sometimes it just adds a complexity to a case that a guardian ad litem can kind of help streamline. And I think most of the time, guardian ad litems, if there's a therapist involved, like they are very apt to execute those waivers or circulate those waivers to have executed and then have a conversation with a therapist and really get a feel for what's been going on. Do you have any words of wisdom or maybe caution for a party who's wanting to maybe like weaponize therapy or to try to somehow have the substance of what the child is talking about in therapy be somehow come to the forefront of a case or kind of weaponize what it is the child's saying in therapy?
Yes, I do have words of wisdom for parties like that. And my words of wisdom are don't do it. Don't do it. I've never seen it not backfire on a party in a case, not a single time. Because again, you're dealing with mental health professionals. You're not dealing with sort of a school counselor or someone that, might not have a lot of experience. Like these are trained mental health professionals that when these children express certain thoughts and feelings and emotions, their purpose is to get to the bottom of that. And a lot of times, them getting to the bottom of that leads them to determine that the bottom of that is mom or dad telling them these things or saying these things to them or encouraging them to speak about certain topics or issues. And when it comes to the forefront that maybe the basis of a lot of these, issues or thoughts or emotions is not necessarily born from the child, but born from sort of seeds that either parent is planting, it always backfires on the parent. It always makes it seem like that parent has an inability to foster the relationship with the child.
Yep.
It makes it seem like that parent has an inability to place the child's best interest over their own best interest, and it never ends up working out well. If there is a true issue with your child and the other parent, there is no reason for why you would need to what we call coach or encourage a child to do certain things. Those feelings and thoughts and emotions will come out naturally in therapy. So I always encourage parties to be very, very careful what they discuss with and in front of the children to avoid any sort of allegations of alienation or coaching, because those can be very detrimental to a case.
So true, Cynthia. I could not agree more. And to wrap up kind of our discussion in terms of these professionals and how, we spoke about parenting coordinators and therapists, are there any main takeaways or what would your advice be to clients when these professionals are going to be involved in a case?
My biggest piece of advice is to always, always, always think before you make a decision or before you say something that you're questioning whether or not you should say it. How would I feel if this was being played out in front of the judge? Like, if the judge was right here, would I be saying these things? Would I be making these decisions? Because ultimately, it's going to come to light whether the allegations from the other parent or something that the child says. And if it's something that you wouldn't feel comfortable having before a judge, or an issue that having been discussed before a judge, then I would encourage you not to do it, or not to say it, or not to engage in that sort of behavior. When you're in any sort of litigation, you're under a microscope, and you don't want a single thing to be said about you not being able to place the best interest of your child above your own. And a lot of times I'll get, well, they're doing this, why can't I do that? And the most simple way I put it to my clients is, when you point the finger, you want to make sure it can't be pointed back at you. Like, when both parties are pointing the finger, they sort of cancel each other out. And the judge just looks at both of you like you both have issues. But if you point the finger and they have nothing to point back at you, well, then that creates a different sort of dynamic in the case that really is more beneficial to you. So you want to be able to show to the judge that you don't have to stoop to that level. You don't have to engage in those behaviors. You really do have the ability to place your children's interest above your own. So that's really the main piece of advice. Like, don't do anything that you don't want before the judge, the parenting coordinator, the therapist. It's okay to be upset. It's okay to be mad. Figure out ways to express that and deal with those emotions outside the presence of your child, and not have that affect that relationship. So that, again, there's nothing that can be pointed back at you, and you sort of create this dynamic where you have the upper hand because you're doing everything right and the other parent can't say the same.
So true, Cynthia. What good advice. And thank you so much for joining me today to talk through the differences and identify exactly what a parenting coordinator is and when therapy could really come to play in a family law case. So I just appreciate your feedback and your insight today. Thanks, Cynthia.
Thank you so much for having me, Katie.
Whether it's a parenting time coordinator or court-ordered therapy, families often rely on these professionals to resolve conflicts. But even with support, many Illinois parents still fall into the same legal trap, often before the case even starts. Don't let that be you. Watch our next video and learn what most parents get wrong in Illinois custody cases and how to avoid it.